SJC-12536, William Scione v. Commonwealth, and SJC-12540, Commonwealth v. David W. Barnes.
Van Dyke, good morning.
Good morning. Mr. Chief Justice, may it please the court. Today marks the 206th day of William Scione's detention, a detention he asked this court to end. The statute under which he is detained, General Laws, Chapter 276, Section 58A, provides the prosecution with the extraordinary power to detain those presumed innocent without a chance at bail. Changes over the last few years have eroded procedural rights of the accused in those proceedings and have lengthened the periods of detention that the accused face. And thus now it is an important moment to affirm a principle central to the constitutionality of that statute as emphasized by this court in Aim and Mendoza, that it only apply to persons that are accused of a specific series of clearly delineated crimes. The crime for which Mr. Scione is accused, throwing, launching, secreting, or placing an explosive or incendiary device, does not fit any predicate clause under 58A.
Can you focus on arrested and charged with a misdemeanor or felony involving abuse as defined in Chapter 209A, Section 1?
Absolutely, Mr. Chief
What the
Justice.
Superior Court judge, I believe, relied upon?
That's exactly right.
Why, I mean, we have somebody who used to date her many years ago, arguably put it there in order to instill fear in her, arguably to burn down her house, or at least to, why would that not be abuse under 209A, Section 1?
Mr. Chief Justice, I begin with page 1 of the record appendix and this court's decision in Commonwealth versus Young, that the elements of this offense do not require abuse in any way, shape, or form, that any person is placed at risk of physical harm. And as this court emphasized in Young, the categorical approach is to be used at the threshold question of whether or not a crime alleged satisfies a predicate clause. And as Young stated, drawing on United States versus Singleton, a D.C. Circuit Court of Appeals decision, that is a question of law to which the facts of the case itself are irrelevant.
Right, but that's a different, that's part of the so-called residual clause, or at least early. That's a different provision. I understand that there it says as an element of the offense, but I'm going down to the very bottom of 1. The word element is not used with regard to the phrase I just described. Why should we limit it to where an element of the offense involves abuse? And if we did that, or if the legislature did that, what would it include?
Your Honor, language such as by its nature or has as an element has not been found by this court or the United States Supreme Court to be necessary to trigger the application of the categorical approach. We know that because this court in...
But that's not the provision I'm focusing on. I'm focusing on only that's the provision at the middle. I'm focusing only on the issue of whether or not this crime constitutes a felony involving abuse as defined in Section 1 of Chapter 209A, not whether it involves a substantial risk of physical force, not whether it has an element of the use of force, just on the issue of abuse.
Your Honor, what all these clauses have in common, and what that clause in particular, the so-called abuse clause, begins with is misdemeanor or felony. Felony is what it shares in common with the other clauses, and felony by its definition refers to the generic offense and not to the actual facts of the case. It's clear that the inquiry is to the elements of the offense because later in 58A, Mr. Chief Justice, the legislature clearly points a court at the hearing itself towards evaluating the nature and circumstances of the offense in paragraph 5 and whether the crime involves abuse. And thus it's clear the legislature knew how to point a judge evaluating a 58A petition to the facts and decided to enable that judge to do so only at the hearing on the petition and not at the threshold question of law as to whether or not a crime is a predicate offense.
So you're saying the categorical approach has to be taken with both?
with all the clauses. So essentially there are
Including the
three.
abuse clause.
That's correct.
Where do you get that from?
I get that from this court's decision in Young, talking about the
Did it ever
application.
construe the abuse clause?
It was construing the residual clause. That's
Not
correct.
the abuse clause.
That's correct. However, what all of these clauses have in common, again, is a generic definition of felony. And
Yeah,
again,
but here, they're saying felony as defined by, and so it's really not just any old felony. We now are instructed by the statute to turn to another statute to get a definition. I don't see why that is so vague.
what the Singleton decision, which this court drew on in Young, talked about, the problem of blending of the two inquiries.
Now, Singleton, was that a pretrial detention case?
That the Singleton decision was a pretrial detention case, D.C. Circuit Court of Appeals, and that this court cited in the Young decision. They talked about the importance of not blending the two phases of inquiry, the predicate offense threshold question finding and the hearing itself, because that would erase a barrier the legislature intended to put up and protract detention analysis in a way that the court found should not occur. That
Well,
effect.
just assume that analysis is one that we use on the abuse clause and not just the residual clause for the purposes of this question. And even assume categorical approach as in Young with the firearm. Abuse, as defined in 209A. What could be more clear? Just get out another statute and look up the definition of abuse as defined in 209A.
And when you look at that, don't you look at elements?
Looking at the elements of the offense, there is no element to the charge against Mr. Scione, certainly, that requires or involves abuse. The reason that it's so important to...
Could you say that again? There's nothing in the charge that...
The elements do not require abuse. They do not require the causing of physical harm to any person. It comes under the chapter for crimes against property, and the crime can be committed in such a way that no one has ever put at fear of any harm whatsoever. This court in Dayton, Your Honor, clarified that the rule of lenity applies to 58A, and thus the benefit of any ambiguity as to the statutory language should be construed to the benefit of a defendant.
Do you agree, though, for a moment, that if the abuse clause doesn't have the categorical approach, that the nature of this offense, where there's a previous romantic relationship and leaving the gas can on the property, is there to send a message that would be within the definition of abuse under 209A?
For all the reasons, Your Honor, that I've stated in the brief, and I do not agree that that is met in this charge. That what's at issue here, while there may be cause to find an attempt to cause fear, not physical harm, nor was the Commonwealth concedes, was the alleged victim in this case ever party to seeing the fire that occurred in this case. But the court need not arrive there, because the benefit of the doubt under the rule of lenity should apply to show that it is the elements of the offense and not the fact-specific inquiry that should be undertaken at the threshold question of whether or not a crime qualifies under 58A. And the reason for that, I suggest, is well discussed in AIM. They equate there the failure to link dangerousness to a specific list of charges to constitutional vagueness. And they talk about where there is a catch-all provision, because the original detention statute was truly a catch-all, which was rendered unconstitutional.
We don't have a catch-all here. We're not talking about the catch-all. We're talking about the abuse part of it.
It's hard to envision, Justice Gaziano, a situation where the physical force clause would not apply, that there's not an element of use, threatened use, attempted use of physical harm.
How about where somebody violates an order of protection issued under the under 209A? Doesn't have to be a physical act.
That is part of the abuse clause, whether or not there's a misdemeanor felony while an order of protection is in effect. That is not at issue in this case, but that is...
No, but it is contrary to what you were just saying. Does not involve a physical force necessarily. It can just be walking on the street where you're not supposed to.
But it is true that that would enable the categorical approach to be applied, because you could look to see whether or not there was a misdemeanor or felony committed while an order of abuse was in effect. And it's the fact of having all the ambiguity swirl around the factual determination that causes the due process violation for a defendant at that initial threshold question. That is the problem. And what AIM talked about is the pressure on, quote, the pressure on judicial officers to detain an ever-increasing number of arrestees. the detention of an individual who could have been released safely under specified conditions is likely to go unnoticed. The pretrial misconduct of any released individual, on the other hand, is bound to augment public insecurity that prompted the adoption of the amendments. In these circumstances, the scope of the amendments has an inherent potential for unrestrained growth.
That's because of a number of things. First of all, there wasn't the procedural due process required by Salerno under the federal Constitution. And number two, there was a substantive due process issue. So I don't see that as addressing issues, void for vagueness issues at all in Salerno. I don't think they even discussed it.
But what Salerno and AIM, Your Honor, do discuss is the importance of specifically delineating the types of serious crimes that apply. And
Not in the context of vagueness.
in the context of making sure that the procedural rights, procedural due process rights of the defendant are protected. And Section 58A is a statute in derogation of liberty is to be strictly construed, and any broadening of it is the province of the legislature and not the court. It is clear that this abuse clause, because it's hard to envision situations where the physical force clause doesn't apply, the abuse clause and the residual clause become a sort of catch-all that applies to arguably very few crimes, but it's important given that the rule of lenity apply, and it's important given the strict construction of the statute, given how long people are held, because really 120 days, 180 days are illusory. Someone is held in practice until trial, that these statutes be strictly construed. I appreciate that my time is drawing short. I do want to briefly touch on the residual clause before turning the
Your
floor.
time is up, so I think you'll have to rest on the brief with regard to the residual costs. Thank you. Mr. Coughlin? Good morning.
Good morning. May it please the court, my name is Christopher Coughlin. With me is Alexander Conley, and we represent David Barnes. David Barnes is charged with aggravated rape of a child, consistent with my brother's argument about the Commonwealth's petition and the initial threshold that they face when moving for pretrial detention. I would suggest that this court, as did the judge in the Superior Court, must limit the review to the elements of the offense. Commonwealth argues that the rape of a child includes, first I would state that Commonwealth concedes that of the three possible ways that 58A could apply, Commonwealth concedes that the rape of a child is not an enumerated offense under the statute. They do argue, however, that the rape of a child would fall under the force clause of 58A. They argue that somewhere within the elements of the offense, although it's not expressly stated, that there's an inherent additional element of force in there.
And if that's correct, we obviously don't need to reach the issue on the residual clause.
Yes, if that were correct, yes.
Am I correct that the aggravation here is simply focused on the age difference?
Yes, so there are two ways in that statute. There are two ways that the offense can become aggravated. One is that there's an age difference, and the second is that the defendant was a mandatory reporter.
So if the Commonwealth is right with regard to the inherent use of force and arising from penetration, this would apply not only to aggravated rape, but to any statutory rape.
Yes.
And what would that say about whether or not, if we endorse that view, does that mean that every statutory rape would also be a forcible rape?
Yes. And I think that falls short because it's dismissive of the fact that the whole purpose of the statutory rape charge is one of strict liability, that there is no mens rea requirement. And the cases that they rely upon rely heavily on mens rea requirement, specifically with respect to the impairment. They try to relate the...
What does it also say that there's a separate statute involved in rape of child by force?
That is obviously a substantial part of my brief, and it was argued both at the district court level and the Superior Court level, and Judge Feely definitely addresses that in his decision and order. I think it's very plain language that not only in the statute, but also on the Commonwealth of Massachusetts websites about providing information to the citizenry of the state about rape and what it is. They additionally delineate rape of a child, and then there's another separate section of rape of a child with force. So they couldn't be any clearer in the online information provided to the citizens of Massachusetts, that there is a separate and distinct statute, and that issue of force is addressed separately. So here, where the Commonwealth is seeking to add that additional element, suggesting that there is this inherent factor present in all rape of a child cases, it's dismissive of the fact that it's entirely and separately addressed in an additional statute and an additional charge.
Do we have to necessarily concern ourselves with the implications in a statutory rape context? Because this is not a First Amendment case. So we're dealing with vagueness as it relates to these facts and a 10-year differential.
Well, I think what
Understand my question? I just want to make sure you do before you answer it. We're not dealing with what are the implications for another statute. A vagueness argument, when it's outside the First Amendment, deals with the facts we have before us as it relates to the statute. Isn't that right?
it is, but I think that the brief addresses that in the fact that it is very difficult, if not impossible, to think of a standard or typical rape of a child case. The offense, the possibilities of the commission of the offense vary so greatly that to suggest that what would come into my mind when someone asked me to describe what a typical rape of a child case is might vary greatly from what might pop into the minds of you justices when you think of what a typical case would be. And Judge,
Isn't that the conflict that Justice always focused on, in that when we look at the residual clause and categorical views of statutes, but when you apply vagueness, unless it's a First Amendment, it's as applied. So there's really a conflict there, and I don't know how we resolve that.
I think that is addressed in, I believe it's the Beckles case, which the Commonwealth wants to rely heavily upon, and Chief Justice Roberts in his dissent seeks to address that issue. I think that the majority distinguishes it, and I think here what the Commonwealth is relying upon is for this court to adopt a dissent in a Supreme Court opinion. Obviously, that would not be permissible. The Supreme Court's decision is binding on this court. This court is not free to ignore what the majority adopted as the law and instead adopt the dissent. And that's essentially what the Commonwealth is relying upon in their argument here, to raise the issue, raise that issue.
I'm thinking of an argument we had yesterday. We were here, you probably were not, in which somebody was arguing with regard to murder, that when we instruct the jury that certain crimes are inherently dangerous. And the argument then was that the claim was that that's a factual finding being made by the judge, and it's inappropriate for a judge to make a factual finding. Commonwealth said, no, that's a declaration of a rule of law, that certain crimes are inherently dangerous. And we have defined in our homicide instructions certain crimes which we claim to be inherently dangerous as a matter of law. This language is pretty similar. It says, by its nature, speaking about the crime in general, not about the particular crime, correct?
I wouldn't necessarily concede that this, by its nature, is falls into that category. Here, the type of commission of the offense could vary so greatly that it could be two 15-year-olds that were engaging in otherwise consensual sex that's prohibited by the law. That is not the case here because of the additional element, but the Commonwealth at no point in their brief really relies upon that additional element as the reason by which they suggest that this is an inherently dangerous crime. So here I would suggest that this is much more in line with the Young case, and is a situation where the Commonwealth has, in moving for dangerousness, has identified a shortcoming of the statute and something that they believe, public policy-wise, should be included, but is not. And therefore, it's a function of the legislature to add it, as they did in Young, to amend the statute if they deem fit. They may not. It may be an intentional omission, given the fact that the possible variations of the offense vary so greatly, that it may have been an intentional omission, so as to not incarcerate 15-year-olds that are doing things that are not akin to other alleged conduct.
So your view is that if the legislature were going to declare certain crimes to be by their nature involving a substantial risk, they would have to identify those crimes, as they did with regard to burglary and arson.
I would suggest that what the Commonwealth, in a sense, is what asking the court to do, is adopt within 58A a provision that crimes against a child are per se dangerousness, or should be included in 58A. And maybe that perhaps they'll lobby the legislature to do so. Whether that fits as neatly as they want it to, I don't know. That's not my job. But I think that's what the Commonwealth is asking the court to basically adopt the rule that 58A would or should apply to crimes against a child because of the innocent nature that they rely heavily upon.
So essentially as a matter of law.
Yes.
But if that were as a matter of law, would there be an issue of notice to a defendant? Is there an issue here of notice if we are declaring it as a matter of law, but it's not in the statute?
Well, it's not referenced anywhere in the statute, and that certainly would be a major departure to identify a particular class of people that are specifically protected within the statute that otherwise didn't exist before. Essentially, I would suggest that the legislature can decide which class of crimes, or perhaps even people, and that is probably a little bit above my pay grade, but they could, in theory, delineate the entire Chapter 265 and enumerate that in the statute, or they could say that any crime against a child below a certain age is covered under 58A, but they haven't done that, and it's not this court's job to do that. And if the Commonwealth wants to work with the legislature to impose or craft those provisions within 58A, they certainly are free to do so, but it's not done now, and certainly it would fall well short of fair notice to Mr. Barnes or anybody else in the Commonwealth.
All right, thank you.
Okay. Good,
sorry.
never mind.
Sorry to cyber?
Never mind.
You sure? Mm-hmm. Okay,
Thank you.
Ms. Semmel, back to Mr. Scione.
Good morning. May it please the court, Catherine Stemmel on behalf of the Commonwealth. I will only be taking the first 5 minutes of our argument, and my sister will take the last 10, and which will encompass the shared constitutional claim. The primary issue in Scione is whether the charged offense involves abuse, as Judge Feely found below, and as a single justice essentially found in denying the 211-3. And this is first and foremost, I think, a question of statutory interpretation. And really, the court doesn't need to look much beyond Young to interpret the involved abuse language in this case. In Young, the court relied upon the plain language in two other provisions, the force and the substantial risk of force provisions, to find that a categorical approach was required. It focused on the language has as an element of and by its nature involves a substantial risk. Language which is quite apparently absent from the involves abuse clause. And really, I think...
Excuse me, I'm not understanding this. Are you saying that you agree that the categorical approach should be taken in construing the abuse clause?
No, I'm not.
Okay.
No, I'm not. So sorry about that. What I'm saying is that the very reasons that the court relied upon in Young to find that other provisions require a categorical abuse approach, those provisions are absent and involves abuse. There's no as has an element of or by its nature involves, and that I think that the legislature's use of that language in two other provisions, which certainly supports a finding of a categorical approach, coupled with its failure to use it in the domestic abuse clause, clearly signals their intent in that area. And I think the defense is suggesting that you should look at other things to find that a categorical abuse approach is required, such as the use of the term felony and misdemeanor, but I think they're asking you to bypass what is really the clear language and import that this court has relied upon before, and which I think clearly signals the legislature's intent. And while the court need not go beyond that plain language, I would just note that it comports with the way abuse is interpreted and applied in myriad other circumstances every day in the courts in the Commonwealth, where a judge looks at the circumstances of an offense to determine whether it constitutes abuse, whether for purposes of 209A or supporting a warrantless arrest, or determining whether an offense qualifies for the domestic violence record-keeping system.
Could I ask you if you were, if we decided a categorical approach was necessary with the abuse clause, would you lose?
I think that I would lose under this offense.
Yeah.
Yes.
So pragmatically then, that would mean, if you're right, that would mean the judge would essentially have to make a fact-finding determination as to stage one, as to whether the crime is even among those which qualify for a dangerousness hearing.
Correct.
And that would
I
focus
think-
as much, it would have to look a little bit to the police report regarding the arrest, as well as whether, the issue of whether the alleged victim fell within the category of a family or household member.
That's true, and I think in most cases, that would probably be the only fact that might not be fleshed out, although it would probably be mentioned in the police report. It really doesn't require much beyond the police report, and I think this is really very similar to the court's decision in DeSantos, where the court pointed out that basically upon the police report, judges can determine whether or not an abuse offense is alleged. And that it is done commonly. And in this case, certainly it comports with this court's and the legislature's often stated goal to protect victims of domestic abuse. In this case, by preventing future harm by those who are most likely to commit it. As for the specific factors of whether it satisfies domestic abuse or abuse, I will largely rely on our brief, but certainly it satisfied the family member. They had a 4-year dating relationship, even though that had terminated some years before. As I think the prosecutor stated at one of the hearings, it certainly had not terminated for this defendant, particularly in view of his actions just a couple days before he set the fire at the bottom of the driveway. But I will otherwise rely on my brief, unless the court has questions specific to my case.
All right, thank you.
Thank you.
Ms. Moriarty, back to Mr. Barnes.
May it please the Court, Marina Moriarty on behalf of the Commonwealth. Your Honors, I'd first like to address the Commonwealth's position that aggravated rape of a child is a predicate offense pursuant to the dangerousness statute because it inherently has an element of physical force against a child who is unable to consent, and then address the Commonwealth's alternative argument in both cases before the Court that the residual clause of the dangerousness statute is constitutional. The element of force intended by Section 58A is met by the act of penetration on a child who is unable to consent.
So would it apply even if we had an 18-year-old and a 16-year-old? Oh, no, because it wouldn't be aggravated, but what about the regular statutory? Because it would still have inherent force and there would still be an incapability to consent legally.
I'm sorry, Your Honor, if the alleged victim was
18 and 15.
18 and 15?
Thank you.
Yes, yes. In that case, it would be a rape of a child, and the elements would be penetration with a child under the age of 16.
And if it was 15 and 15, it would be the same.
Yes, Your Honor.
Aggravated?
Wouldn't be aggravated, but it would still be, you would still argue that it's a crime of
Statutory.
force.
Yes, Your Honor. So the Commonwealth's position is that in this case, we are dealing with aggravated rape of a child, which may influence a later, if we get to a residual clause analysis.
So let me just clarify then, in this case, it wouldn't apply in this case because of the age difference, but in another case, we could potentially hold a defendant who had had consensual sex with somebody who was 15, if the defendant was also 15 or 16 or 17 or 18, they could be held under a dangerousness hearing, is that right?
A dangerousness hearing could be held, yes, Your Honor.
Yes, okay, a dangerousness hearing. And then it would be up to the judge to decide if they're dangerous. Okay.
Yes, this
Got
is
it.
simply a triggering point, deciding whether whether rape of a child is a predicate offense. It's true that a judge need not find force, and that is a separate offense. However, every jury must find penetration. In this case, penetration is synonymous with force. Penetration is the force, just like touching is the force in the context of assault and battery with a dangerous weapon. The assault and battery with a dangerous weapon requires a touching, no matter how slight. It would seem incongruous to believe that a penetration of a child would not be equivalent to that kind of touching. Just as an extremely intoxicating...
Well, let me stop you there, because I know that you argue that indecent A and B would trigger it, but an indecent A and B would be analysis to an offensive touching, which would not be within, it's harmful. I mean, the statute does not speak about offensive touchings in terms of assault and battery. It speaks about harmful or dangerous. I'm trying to look to the language of the statute with regard to the elements.
I'm sorry, I don't understand your question, Your Honor.
Yeah, it's because I didn't frame it very well. Let me see if I can do better for you. And I'm looking for the language at issue with regard to the elements. So the elements that we're focusing on involve an assault involving the use of force, correct?
In the context of an assault and battery with a dangerous weapon, or an indecent assault on a child under 14.
Okay, and I'm trying to focus on what the language would be. And I'm losing it, so I'll get back to you when I find, for some reason I've lost the statute in my notes, but I will get it.
Isn't there a comparable force clause in the Armed Criminal Career Act?
Yes,
We've construed that quite differently. Okay, we've construed what force means quite differently there, haven't we?
I don't think so, Your Honor. I think in
I
the,
have a definition that it requires violent or substantial force capable of causing pain or injury.
yes, Your Honor, I think that in the same context, penetration of a child can be capable of causing serious injury and or pain.
What was the age difference here?
In this case before the court, it was a 15-year-old child, and I believe the defendant was 42.
Yeah, I'm sorry. What I'm focusing on is our decision in Eberhardt, which said the phrase physical force means violent or substantial force capable of causing pain or injury.
Yes, and I would suggest that in the context of 58A, in the context of penetration of a child, penetration is capable of causing injury and or substantial bodily
So
injury.
does that mean that every statutory rape is a forcible rape?
No, Your Honor, I think there's a distinction between what the court can find is a predicate offense pursuant to Section 58A and what a jury needs to find
Why?
as an element.
Why?
Simply because it's not an element that the jury needs find does not mean that penetration is not synonymous with force for the purpose of Section 58A.
You're saying every statutory rape case would be subject to 58A, but that doesn't make any difference in terms of convictions. Is that what you're saying?
Yes, Your Honor. Clearly, if a prosecutor charged forcible rape, there would be no issue with 58A. If a prosecutor charged forcible rape, the jury would have to find that the penetration was accompanied by additional physical force to effectuate the penetration. But in this case, this court finding that penetration is synonymous with force, just like touching is synonymous with force in the context of ABDW, would not mean that every statutory rape, every rape of a child is a forcible rape of a child. It would just mean that it's a predicate offense.
What about our cases involving youthful offenders? There was a recent case, NM versus Commonwealth, 2017 case written by Justice Budd, where we talked about the threat of serious bodily injury in that context, and we said not all statutory rapes rise to that level. What do we do with that?
I think that in those cases, in the youthful offender context, those are fact-specific,
Right.
and the Commonwealth need proof-specific facts. I think here we're looking at an elements-based approach, and if you simply look at the element of penetration, penetration requires a degree of force.
Even with two 15-year-olds?
Yes, Your Honor. It simply triggers the Commonwealth's obligation to present evidence at a hearing.
We have found penetration to constitute force only when the victim was unconscious or unable to resist.
And that's exactly the child's position, which this court and the legislature has.
They're not unconscious or unable to resist. We've declared as a matter of law that they're unable to consent, but generally they're quite conscious.
And what do we do with the situation where you have another statute, the rape a child by force?
Again, it goes back to the purpose for which this court determines the definition of penetration. It's not a It's not determinative, simply because force happens to be an additional charge, a different charge that carries actually the same penalty that rape of a child does. It's aggravated rape of a child that has the 10-year mandatory minimum. It's not determinative in this case. This court can in the Commonwealth's position, fairly easily decide that penetration is equivalent to force, and therefore, for the purposes of 58A, for the purposes of triggering the Commonwealth's obligation to present evidence at a hearing, it's a predicate offense.
So is it your position, following up on Justice Galziano's question, that you could supersede an indictment here and charge the same person with forcible rape of a child?
Yes, absolutely. And I would suggest that for many reasons, it's in everyone's best interest for the Commonwealth not to overcharge a case for the purposes of attaining a 58A hearing, but that it's in the public interest to continue to protect children and find that where a child is unable to consent, penetration is equivalent to force.
I might have just misunderstood your answer. Are you saying that every statutory rape case could be rape of a child with force?
No, certainly not every case, Your Honor, but in theoretical scenarios, a prosecutor may charge forcible rape and then decide at trial that it's too close of a call and simply ask the jury to return a verdict of rape of a child, which is easier, one fewer elements for the jury to prove, but has the same penalty.
But you're saying that it's purely a matter of prosecutive discretion whether or not a prosecutor charges a defendant with forcible rape of a child when it would otherwise be viewed as a statutory rape.
I'm saying there are instances in which a case could be viewed in both instances, in both
There
ways.
certainly are times in which there is force, but I'm speaking of times in which there's no indication if the victim were an adult that there would be a claim of force. You're saying whenever there's a child, there is inherently the use of force, and therefore a prosecutor could charge every statutory rape as a forcible rape of a child.
No, Your Honor. I apologize if I misspoke. Not every case could be charged as a forcible rape of a child.
Which would not be if your theory is that every penetration of a child is forcible.
No, Your Honor. It's simply the Commonwealth's position that the penetration is equivalent to force for the purpose of Section 58A.
Can I just play back what I think you're trying to say? I'm not sure I agree with you, but let me see if I at least understand your argument. What you're saying is penetration, no matter how slight, constitutes force. In the context of a child, because they can't consent to the penetration, and while that may not be a required element, that force can be contemplated within the requirements of abuse under 58A.
Yes, Your Honor.
That's what you're trying to say, right?
Yes, Your Honor.
Okay.
Which means that when the legislature used the term by force in the rape statute, it meant something different than when they used the term force in 58A.
Two different purposes, Your Honor, yes.
Okay, thank you.
Thank you, Your Honor.